Hello, I am Stephanie Joy, the attorney at All Things Social Security and Joy Disability Law. Your video is about to start. I just wanted to remind you that if you click the join button below, you can learn more about the memberships offered at a very affordable price that can give you a little more direct attorney answers to your questions. Have a great day and enjoy the video. Good morning. Quick share here. Little glitch in the day, although it was kind of not unexpected. We had a hearing this morning scheduled for 20 minutes from now. And of course, when I have morning hearings, I'm up and at it super early, making sure all screens are working, making sure all my docs are up that I need to be looking at. I got my notebook. That's the old school way, but I like to scratch things down. And this was an overpayment case. I know we talk about overpayment cases, and I've said I don't take them, and I don't anymore. But I also don't drop ones that I already took. So this is a case that I feel like is a slam dunk for the claimant, but it's unfortunate that you have to go all the way to an ALJ to achieve it. And there had been situations where the claimant had explained to the SSA, submitted documents to the SSA. I submitted documents to the SSA showing how it wasn't an overpayment. In conversations with the SSA, depending on who you spoke to, one particular SSA staffer had said to the claimant that, oh, I see exactly what you're talking about. Oh, yeah, this should be no problem. And the next thing you know, the overpayment allegation continues and she has to appeal. And that happened through recon. And then we're at ALJ hearing. The matter is, we've discussed these kind of things before. It was a situation where the SSA understandably thought there was the work from one employer was actually also earned at another employer for the same year, therefore putting the person over SGA. It was a mere glitch. The claimant had reported her work online, unlike in the past. This is for about a year of overpayment, where she reported the wrong employer name. So, and that was because for a short period of time, the employer had used a payroll vendor, processor, whatever. And they had the payor as themselves, if I have this straight, while the person still worked for the same old company as always. So when the person went in to report their earnings, they reported as working for the same old company as always, not realizing that the answer should have been the payer vendor, because that's what's going to show up on a W-2. Who knows, right? I mean, it's just an employee. They don't know the intricacies. So, if you say you make 10,000 at one, and then the actual employer is reporting 10,000, then under the payor's name, because the payor is reporting, not so much the employer, but the payroll vendor they hired. And then you go in and you say you made 10,000 at this company, the actual employer. Now you got two reportings of two incomes from two different names. So that's where the SSA got the original information. So the mistake, it's understandable that they thought it was. What is troublesome is that upon significant proof, including the 1099s from both of those, the vendor and the employer, showing that combine the two, they're not as big as what you thought. They're still under SGA. Not to mention the employer was kind enough to write a letter explaining how they use this vendor, and the employee only worked for one of them, et cetera, et cetera. So we're heading to hearing. We had all the documents in. This is something called a paper file. It is a nightmare when it's a paper file. And I feel like overpayment, I don't know if they all are, because I don't tend to do them, but everyone I've ever had is. So can't speak for whether that's a rule or just, the technology of the time. So paper file, from our perspective, it's a nightmare. I can't go into the ERA and see that what I submitted is in there. I have to fax it. And while I have fax confirms, I know from prior history that a lot of those faxes never get into the file. because they're not going directly into the file, apparently. Not like if it was ERE and I'm uploading it. So speaking on and off with the hearing office, very, very nice assistant to the judge. And I had submitted everything but the kitchen sink because I don't know. I mean, if the SSA didn't listen to what we said, am I missing some issue? And the judge is going to be like, oh, deny because, and you don't have this in, then I can't award. I just didn't know. So I sent in, wow, like 5 years, no, sorry, 7, 8 years of bank statements proving what was received, what wasn't. Each year was about 160 pages. And this is by fax. I can't even tell you. And when you use a digital fax, only certain sizes can go, and you have to reduce the size, which I am not techie. So this was a bit of a headache. I probably spent 10 hours. Well, maybe 10 hours combined on this little section before hearing. This has nothing to do with everything before. And this is all pro bono, I might add. So I'm like a dog with a bone though. So, and the claimant is very deserving. The assistant who has to then exhibit the stuff is like, woo, I'm like, I'm so sorry. I'm like, if you want to, I don't even think the bank records are needed. But if someone says to me, do you have more proof? I'd have to say, if we don't send it in, we run the risk of them not accepting it after the deadline. So you have to go overkill if you're going to cover all. Imagine not submitting something out of laziness, like the 10 hours or whatever. And it turns out that particular adjudicator or judge is like, not accepting it now, past the deadline. So I did it. I just rather be safe than sorry for my client. I really don't think, I think everything else is so on point. You don't need to go through all that. And I went through those banking records and that was a headache. I can't even tell you how many hours have been put in. So here we are, client hugely anxious. In fact, the medical impairment that has been disabling for many, many years is severe anxiety. I mean, body sickening anxiety. So, and it's a young person, actually. I mean, young, you know how we say young, under 50. So, talking with the OHO yesterday, and then the assistant did say that the judge might be canceling the hearing, but wasn't sure. And I was trying to make sure they got in my stuff because, like I said, I can't go to ERE and see it. So I have to call and be like, do you have my so-and-so, and this, did you get this? I mean, really, really a pain and mind boggling. So she was probably a little overwhelmed also because there was a lot of stuff. And of course, I never got the paper file by email, which is encrypted, by the way. That's a whole nother headache. So we couldn't even find out what was in there and not in there. That's why all the phone calls had to be made. I couldn't, we had just gotten that file. I'd spent probably 6 hours revamping that file, turning it into something where I could then rename each exhibit, because the exhibits were exhibit 1, miscellaneous, exhibit 2, SSA letter. No. I need things defined, because I'm going to be drawing on that. When I say judge, go to 1F, it's the letter of blah, blah, blah. So anyhow, very time consuming. There was that hint of it being canceled. So I was kind of like phone tagging throughout the rest of the day yesterday to find out, because I got to tell my client. I mean, this person does not need to be going through another night being sick over the fact that there's this anxiety hearing going on. But I didn't hear back. But I heard back this morning about an hour and 45 minutes before the hearing saying it was canceled, and call me back so I can, judge has a few instructions. So that does happen. I had to call the client and tell her. Most people are it's a bittersweet thing. It's like, oh God, I can relax now, but I still got the case going on. So it is usually better just to get them done. But in this case, and I asked, it might be that this would be an on the record award. That would be great for this claimant. I think it's going to be because of the documentation. So I think he sees the really strong proof in there of what would happen. And now just wants it kind of, now that everything's kind of scattered all over the place and with this silly little paper files they have, or they call it E&M or something now, on their side, it makes no difference to us. It still stinks. They can email it to you. But like I said, There's multiple emails of the file. In this case, there's only 3 because this is not a disability file with medical records. This is all about overpayment. Although my other overpayment file is like, anyway, 3 emails. They're each encrypted. I know the password, no problem. But you can't then manipulate things. I can't change the title to the exhibits to make them actually more accurate. I like to highlight the ones that I'm going to be drawing to the judge's attention if need be in the hearing, or drawing to mine, and I could just click on it then. So this is what I like to do, being the anal person I am with my cases. And you can't do that with that unless you get it unencrypted. And the only way to do that, because they don't give you the password to do that, is to save it all to a flat thing. You could print it out on hard paper and scan it in, but I'm not wasting my ink on that. I have a laser printer. Each cartridge is $100 and I need 5 of them for it to run. So not doing that. Plus it's wasteful. So I print it to a flat thing that is on the computer. It's like printing it to a PDF, but it's really more of a TIFF, or you could do it to a JPEG. And then you go back in, and I have a Mac system, by the way, so that might be why this works, but I think it's through Adobe as well. Highlight all of them, drag it into a PDF, and now you've got your flattened, your JPEGs or your TIFFs all in one big ugly file, not bookmarked. The exhibits are not noted. Then you have to go back to the original thing and find each one. That's 3 pages. These 3 pages are going to be this exhibit. These 9 pages. Real headache. That's why it takes so long. And this would take you long. I mean, if you're pro se and doing this is really what you kind of have to do if you want it to be working for you. You need to know your file inside and out. You got to know what exhibit you want to point out to the judge, to show that, yeah, the employer said this, the exhibit number, blah, blah, blah. Da, da, da. You have to kind of work with their numbers, their exhibits. It's not your, well, there was a letter, judge. Da, da, da. You know, you really want to be specific. So anywho, it looks like it's possible that this could be an on the record award. So I'm going to put together a brief. We kind of already did this, but in a much more informal manner because we didn't have anything. So it's kind of like piecemeal. But now that we have everything I think we need, I'll be putting that together. Probably, I really need to do it in the next week so that the judge can decide whether he has to reschedule a hearing or not. He's probably I don't know how much time he's giving me, but I do have a huge overpayment trial hearing coming up shortly thereafter. So I don't want it to really impede with that preparation of that one, which is way different than this one, way more complicated, way more ugly. I'm not happy about it. Never doing them again. But in any event, that's what happened today, guys. They get adjourned at the last minute. This happens with disability hearings as well. Sometimes a judge can be sick. Sometimes a vocational expert they were going to use isn't available and they can't snag one real fast. Sometimes if it's a medical expert that can't show up, there's a variety of reasons. And it's so frustrating, I know, to claimants because they've been waiting a long time and that's their perspective. And I get that, but it is what it is. And you can't really refute it, right? I mean, you can't say, no, judge, hold it now, even though everything is unprepared. And that's probably going to be a denial if that would happen. But a judge won't do that. They're far more responsible. They're not going to let you lead the way to your own demise, at least not by using them to have a hearing when the hearing can't go forward properly. So anyway, here's where we are. In this case, I think it's probably a good thing. Hopefully, potentially, we'll see. I'll get my ducks in and cross my fingers or say a little prayer. I'll talk to you later, guys. Have a great day. Bye-bye now.